Hi folks, this is Attorney Kip from Malik & Malik, and this video I'm going to be talking about independent contractors in the context of trucking jobs. So this is kind of a situation that we run into quite a bit, or not quite a bit, but we do occasionally run into it with folks, they're truck drivers, they're over-the-road truck drivers, they're box truck drivers, and they get an injury. Either they're driving and they get in a truck accident, or they're loading on their truck and something happens and they get injured. They file a claim, and then the employer is disputing, hey, this person is an independent contractor, they're not an employee, and therefore they're not entitled to participate in the workers' compensation fund. So this is a barrier that we have to get over. We have to prove that the injured worker is an employee of the employer and not an independent contractor. And most of the time when we run into these independent contractor disputes, it's in the context of construction jobs. So folks are roofers, framers, doing drywall and these sorts of things. They get injured. A lot of times that comes up. In the context of construction injuries or jobs, you have to use these 20 factors, and you evaluate the 20 factors. And if 10 or more go for the injured worker, then the injured worker should be deemed an employee of the employer. So with trucking situations, they don't apply the 20 factors. They use the whether the employer controls the manner and means of how the job is done. And so depending on how much the employer puts into that situation, determines whether the person is an independent contractor or an employee. So I'm going to talk about two 10th District cases that deal with trucking situations, and then I'll talk about one Supreme Court case, an Ohio Supreme Court case, and how they dealt with the issue. So the first 10th District case is called Brown versus CDS Transport. I'll try to find the actual case and put it in the link so you could read the case yourself. But in this case, Brown was deemed to be an independent contractor, and because he was deemed to be an independent contractor, he can't file a workers' comp claim. It's not a compensable workers' comp claim. And so the court looked at these things, and they found these things, pointed out to Brown being an IC. So Brown owned the truck that he used to deliver the loads. This seems to be really important. If the truck driver owns their truck, that's a pretty big factor in whether or not they're an IC or an employee. He was given a fuel card and a blank check by CDS Transport, but the money that Brown spent for fuel and expenses was then deducted from the amount he was paid after the end of the week. He was responsible for payment of highway use taxes, and then he received 70% of the gross loads delivered, and then he determined the hours he worked. It seems like, and you're going to see this in the next case, that when the percentage of the load that you get, like if you deliver, because a lot of these cases, the employers will be paid per load, and the IC or the Industrial Commission is like, well, if you're paid per load, that tends to suggest that you might be an IC. And you'll see in these cases, in this Brown case and the next case I'm going to discuss, the person who was deemed to be an independent contractor got a fairly significant percentage of the load that was delivered. So they weren't paid per hour. Instead, they were paid percentage of the load delivered. In the next case, the guy again, this Barkus, was found to be an IC, and it's the case is 10th District case, Barkus versus Bureau. Again, Barkus owned the truck. A big factor suggests he's an IC. He was responsible for all expenses related to the operation, maintenance, and repair of that truck. And then what ended up happening is Barkus leased his truck to the trucking company Siva, and then it was suggested, I guess, by Siva that Barkus purchase another truck. So he purchased another truck, leased that second truck to Siva. And then just go back and look at the other guy got 70% of the gross load delivered. Barkus received 65% of the total amount of money for each shipment picked up and delivered for SIVA. So 70% versus 65%, still a significant percentage of the load that the person received. And so if you're getting that significant percentage of the load received, you may very well be an independent contractor. And if that's the case, it's incumbent upon you, the worker, the truck driver, get your own workers' comp coverage. Buy coverage for yourself. Be protected in case you get in a truck injury, or you lift something and hurt your back, or fall down, or whatever. Don't run into the regrettable situation where, oh my gosh, you had this major injury, and then it's deemed you're an independent contractor and you're SOL. So don't do that. So these guys both deemed independent contractors. Next case, it's interesting the way the facts turn, and all these IC situations always heavily fact dependent. It's like they'll twist and turn on the weirdest little things, and that's just how these kind of disputes run out. But very factually intensive. It's an Ohio Supreme Court case, Bostic versus Connor. It affirmed this 11th district decision, which again affirmed the common pleas decision that the decedent. So in this case, the injured worker he died. So that's horrible. And so what ended up happening is his wife filed basically a survivor claim. And so you have to prove that this guy, in order to get, for that person to benefit from this guy, I mean, it's not benefit, but in order for that person to get benefits through the workers' comp claim through her husband's death, her husband has to be deemed an employee of the company. So, and fortunately, in this situation, Bostic was deemed an employee, not an independent contractor. So, and it's kind of interesting. So, when you read this first fact, Bostic was deliver steel from Middletown, Ohio to Michigan for Bob's Truck Service in exchange for 63% of the gross revenue received by Bob's Truck Service. Bostic set out from Middleton. His tractor broke down in Findlay, and he left the trailer and the load in Findlay. His trailer was towed back to Middleton. I guess his tractor was towed back to Middleton, and then Bostic negotiated a deal to complete the trip with Bob's truck, and the deal that he struck was that he would use the truck owned by Bob's truck. So the tractor or the truck, the thing that drives. He was provided with a credit card by Bob's truck to pay for gas and repairs, and this is important. He would receive 26%. Not 63% of the gross revenue for the portion of the trip from Findlay, Ohio to Michigan, and 26% also incidentally was a percentage that Bob's Truck Service employees received for loads that they delivered. So, and then finally he was instructed to return to Middleton, Ohio after delivering the steel to Michigan. So he was not allowed to solicit a return load or negotiate a return load with somebody else. So the court in that instance, Supreme Court, the Court of Common Pleas, and then there was the 11th District, and finally the Supreme Court affirmed that Bostic was an employee of, I guess, Bob's truck. And it's interesting that you see that it had to go from Court of Common Pleas to 11th District to the Supreme Court. So Bob's truck was fighting this at Court of Common Pleas, 11th District, and finally at the Supreme Court, and ultimately Bostic won. But when you look at it initially, if Bostic rather would have gotten in this fatal car accident or truck accident rather from Middletown, driving from Middletown to Michigan, before the second part, then he might not have been deemed an employee. But what ended up happening is when he went back down to Middleton and negotiated this new trip, his label or whatever changed, or he became, by the facts of the situation, an employee of Bob's truck rather. And that's how these things turn. You got to look at it. Not only it's on a fact by fact basis. But at the time that the injury occurred, are you an employee or are you an independent contractor? At the first part of the trip, the argument would be if he's driving his own truck and he's getting 63% of the gross revenue. That's very similar to these 10th district cases. So in that instance, if he got his fatal injury there, probably an independent contractor. But when after his truck broke down and negotiated the new thing, he's driving somebody else's truck. His gas and repairs and whatnot for Bob's truck is being paid by Bob's truck rather, and then instead of receiving the significant portion of the percentage of the revenue for the load that he's delivering, he was receiving 26%. So again, the courts are going to look at whether the employer reserves the right to control the manner and means of doing the work, and in this case, they deemed it was by looking at those different factors. And every one of these, again, it's going to be fact by fact basis. Definitely, there's a situation where you don't want to play around with this. You 1,000% want to get a workers' comp attorney involved. And the other thing, you want to gather as much details and evidence and whatnot as you can. The employer is going to be gathering as much details and evidence as they can. You'll find with some of these things, some of these situations will be these bigger operations. Sometimes you'll be dealing with smaller employers. And you'll find that with these independent contractor things, whether it's these trucking deals or, these construction type independent contractor situations, they're typically very contentious because they're smaller employers. They have more at stake, and particularly if the smaller employer didn't get workers' comp coverage, for his employees, that could be a massive financial hit for that employer. So they're going to fight. Anyways, as I say in all these videos, don't mess around. At least consult with a workers' comp attorney if you have a situation that arises. It's going to pay dividends. Ask your friends, your coworkers, your neighbors, your doctors, whoever. Hey, do you know a good workers' comp attorney? And then get that recommendation. Talk to them. Look on Google and search. Find somebody. Talk with 1, 2, 3, 4, 5 workers' comp attorneys. Sign up with the one you like, but don't do this stuff alone. You're gonna get hit if you do. It's not gonna work out well. Anyways, I'm gonna put the cases, if I can find them. I'm gonna put them in the notes section. And if you have any questions, comments, etc., leave them in the comments section. And then my information to reach me will be available there as well. I wish you stay safe, and then wish you have a pleasant day, week, weekend, whatever you're doing. Thanks for watching. This has been Kip from Malik and Malik. Thank you. Bye.